So AI is all over the place, including for patents. And so that's what we're going to talk mainly about today is AI for patents. And AI is very powerful. It's improving all the time. But IP and patents is complex and nuanced. And also the stakes are high. Patents are often, yes, very costly to produce, but they are very valuable, and they can, millions, if even tens, hundreds of millions of dollars can be on the line in a litigation between patents. So these are high stakes documents. And so, as we've said, AI is very powerful. AI clearly deserves attention from IP practitioners. But the effective and efficient implementation of these tools is not always straightforward. So what I'll do in the first half of the talk is give a background summary of the current status of these tools broken down into different areas. And in the second half, Ashley will take over and talk more about the future and how these tools may be implemented, and we'll have a discussion around those topics. So breaking it down in the current status, there are different tools for different functions within patents. So there's tools for searching, proofreading, at the patent prosecution stage when the patent is at the being examined by the patent office, and there's tools to help facilitate that process. And then drafting. And there's two different sorts of flavors of AI for drafting. One which has a lot more guardrails, sort of the rule-based AI, and then also the large language model or the ChatGPT type AI for generative AI drafting. So we'll talk about all of those separately. We're not going to discuss any particular tools today. We will not endorse or bash any tool or any company, but just to sort of give a list, there's a lot of tools for patents out there, AI tools for patents, and there's more all the time. But just to list sort of a few, there's lots of big companies, Microsoft, Black Hills, Dolcera, patent bots who have tools, PatSnap. There's also smaller companies who are coming out with tools that are specific to patents. You mentioned PatSnap and Patent Pal. There's many others. So not going to really talk too specifically, but in general, we'll talk about kind of the different tools that are available in these different areas. So the first area is IP searching. This is something that it's a necessity, really. Whenever you file a patent or when the patent office is examining a patent, the prior art, searching the prior art is key. And so, what's interesting about an AI-enabled search is you can plug in a whole bunch of text into a search field, and the AI will find documents, references that are similar to whatever you plugged in. So that's really helpful in various situations. Maybe you have a patent that you want to find things similar to. You can plug in a whole claim into an AI search box, and the AI search will find references that are similar to that claim. Even at an earlier stage, if you have what's known like as an invention disclosure, maybe you have a write-up of your invention, but you don't have claims yet, you can plug an entire invention disclosure into a search box, and then the AI search will find references that are similar to that disclosure. So that's really interesting, and AI is very good at finding references that Boolean searches may miss. A Boolean search would be where you have keywords, bicycle and wheel and oval or something like that would be a Boolean search. Whereas if you had a whole description about we have a bicycle and it has oval wheels and the wheels are good because that makes a very bouncy ride or whatever, then you can plug that all into the AI search, and it will find references that are similar. So this can be good and bad. And actually, I've spoken with training people that are training at these companies who have these AI search tools that are training people on how to use it. And some of them have actually said AI might miss some references that Boolean searches find, and vice versa. the AI search might find some tangential weird reference that's related, but has totally different keywords that a keyword Boolean search might miss. So it's kind of nice if you want to do a comprehensive search to use both. The one or the other, they both have limitations. And so
Dave,
that's
have you heard feedback on any kind of like obviousness, inventive step, kind of like how good it is at finding? Because I know like PQAI is like a free tool that claims to do it, but in my very brief experience, it's hard for a machine to kind of put those together. But or does anybody else have any experience with tools that claim to do those kind of combinations?
I'll say a little bit, I guess. And my experience was sort of similar to yours, is that sometimes the AI finds connections that I wouldn't have expected or thought of from a keyword, but I've done some A/B testing between Boolean searching and the AI searching, where I put in a paragraph and then I took out what I thought were the keywords and did a Boolean search. And I thought the AI search in some of those cases, not all, but sometimes it missed some really key references that I thought, were top 5 on the Boolean search from what I thought the keywords were, which was odd. But then, like you were saying, it may have it may have some potential to find some of those more disparate connections for an obviousness reference. But yeah, I've seen it miss some things that I thought it should find. So yeah, I think, yeah, exactly.
So one of the things I've noticed is when a company is bragging a little bit about their natural language processor sophistication, I do find that I get better answers, or I get more precise answers, or at least if they're giving me 2 or 3 references, I can ask it and get a good answer to the question, how can these 3 references be combined to cover this claim? Or are these concepts in these 3 references, right? Like, so it seems to me, if you've got a really good natural language processor, it's patent savvy and patent taught, right? Because we have special rules and really odd things about language. And you can intermix it with somebody who's asking it specific questions, you might get better answers. And this is along the same lines as giving a good prompt, right? To get a good answer.
Absolutely. Yes, exactly. And that's going to come up. I mean, again, that's a great, I'm glad you brought that up, because that's exactly, I think, at least today, crucial for getting good, high quality outputs from these generative AI tools, especially, is prompt engineering, like asking it sort of more specific questions that you really want the answer to, and then it can provide better quality outputs. Yeah, right. So there's also some, a lot of new software innovations. It's hard to predict how they will be used, and there's a lot of interesting applications for AI searching. So, for instance, what's important in a patent is that what was known, or what is published at the time that the patent was filed, or at the first priority date. And so you could have a search tool that could actually go back in time and ignore sort of everything that's published since, and know that only have it be trained on information up until that point. For instance, this is hypothetical now. I don't know of any tool that is currently doing that, but that's an interesting application for how some of these software, this AI, could actually be really helpful to even in the parlance of the patents, determine what a person of skill in the art, or PHOSITA, would have known at that time. And the other thing that comes up again and again is that comprehensive searches are very costly and time consuming. And so at the patent office, especially, I think, the US Patent Office is a great example of this. The patent examiners are given a certain amount of time to examine a patent, and they can only really do a certain amount of searching, a certain amount of considering before they make it a conclusion about whether it's rejected or allowed. And so, this is something that's often talked about, how a lot of issued patents don't hold up in litigation or even at the PTAB. And I know Ashley will kind of also talk about this in the second half, so I won't dwell there. But AI searching has the opportunity to address that problem, at least mitigate that problem, where it could help a more efficient search tool, and AI may be part of that, could help a patent examiner find more relevant prior art more quickly, and therefore this quality control, if you will, at the patent office could be done during prosecution while the examiner is considering if a claim should be allowable or not, rather than afterwards in litigation when someone has spent tons of money paying people to search for tens or hundreds of hours. So I don't know if anybody has any thoughts about that now, or we could, Ashley, maybe we should say, if that's going to be a discussion point later, we can come back to that.
Yeah, I'm good either way. Yeah, I mean, it is a fair point. So, yeah.
I have a comment. So at litigation or at post-grant is where people are spending all their money on searching and on finding all of these issues, right, with your patent or that you're infringing their patent. So I see this AI kind of movement as a really good tool to help us get better patents, to help both sides be better seated with their claims and with their drafts, so that more of this isn't happening as often in litigation, and we aren't overstepping each other, right? So if you can, like in the bottom of this slide, it says, use both, use AI and Boolean. If we can do that up front, if we can do that during prosecution while, we maybe are deciding on continuations, right? And we can throw in other searches so that we aren't having clients waste money. I think that's powerful. I understand it can be a slippery slope, but I think when you're using something mitigated by human intervention that looks at output results that really are just search based, I don't think there's a whole lot of problem. I think the bigger problems with AI come into the drafting perspective, but for search, I think it's brilliant. Just an opinion.
Yeah, and I've seen examiner office actions come back where there's a line, the examiners always are very specific about what terms they've used to search, et cetera. And now I've seen it a couple of times where they've used an AI search tool.
Oh, interesting.
Yeah. So it's happening.
Hopefully.
Go ahead.
Yeah, hopefully it makes for better searches, because not all searches from examiners are great. So if we can improve from that side, we just get better patents.
Right.
Yeah, this is one of the things we've, not to get too far ahead, because I know we'll talk about it a little bit later in Ashley's section, but it's something we talked to Judge Michelle about a little bit. And, he said that that's something that he and, Capos have kind of like, kicked around forever, is this notion of a gold-plated, patent system, so that, you, like, how do we get something that's closer to a patent that doesn't pend indefinitely until it's tested, in a court? And so they've sort of like philosophically talked about, what a sort of separate track, would look like. And, what they've sort of concluded is that it would be way too cost prohibitive for inventors and also for the PTO and the examination process to do that. But gosh, what if we could get to that sort of result by using potentially lower cost AI tools that scaled infinitely better than the human resources that aren't affordable to solve the problem?
Yeah, absolutely makes sense. I mean, there's good reasons why the system is the way it is now. You don't want you want small companies and individual inventors to be able to afford to file a patent. And so, right, if these efficiency tools are the answer, right, to keeping the costs down and having the quality go up. Yeah, right.
Yep.
Okay, so the next topic is like, we can just breeze right over because this is very standard. Is there AI proofreading tools for patents? And these have been used for many years. These are highly detailed documents and the wording really matters. And so for years, I know there are tools out there that do antecedent basis checking for claims and checking to make sure that all the terms in the claims have been supported by the spec. So all these proofreading tools are very well known and commonly used, and they are great quality improving and time saving tools. For efficiency is exactly what AI is good at. The next topic or area is in patent prosecution. And we started to talk about this a little bit, where examiners are using AI tools for searching. There are some really interesting tools out there and I think this is a great area for AI, where you could analyze cited prior art, that an examiner has cited in a rejection, may only be 2, 3, 4 individual references, and compare that to the currently rejected claims and to the specification. And then the AI can help the patent practitioner understand the rejections by summarizing or by comparing and contrasting these things. But there are even tools out there now who are starting to suggest amendments, improvements to the claims to overcome the rejections, because this is what AI is good at. They can analyze the documents, they can see differences. Oh, here are a few embodiments, a few inventive concepts that are in your specification that the AI didn't detect in the prior art. So these could be good candidates for claims to get around this prior art. Very interesting area for AI, because I think it's more bounded. It falls in the rule-based category. You're not going to have it generatively inventing a bunch of stuff that's not real. It's more like comparing this limited set of information. Yeah. Does anybody have any?
Yeah, so you would think, but the few tools I've used to play with this concept and this exact set of events, you don't always get explicit specification support that would be covered in Europe, or that even in the US sometimes. I've had it not necessarily hallucinate, but grab a word from one part of the spec and put it with a word from another, try to amend. But I do find this process, rather than getting the amendment, to say things like, what concepts could I amend into this claim to overcome this prior art, right? And so then you begin to see, well, this isn't covered and that isn't covered. And so then you see these concepts that break out and you say, oh, this is important to my inventor. Let me go back to the specification and see. So I find that easier with this. I don't know, maybe it just hasn't come far enough, right? That we're getting exact, explicitly supported amendments in proposed amendments.
I would agree with Chris. I did use one of these to try to get it to draft a rough claim with prompts, and it gave me a great claim. But then when I tried to find some of the explicit support, I was kind of surprised that was in the specification. I was like, wow, we had that in there. We did not.
So it sounds like this. Yeah, it's very similar, and it fits in with these other categories where it's spitting out something that looks plausible, that sort of at the face of it, it's like, wow, look at how great a job it is. But when you really dig into the nitty gritty, it's flawed. And we'll talk about this in a minute more for the generative stuff, but it seems to apply here as well. There was a good quote from an article I saw that was basically saying the current state of large language models in AI, particularly for drafting patents, it's limited, and the output is going to be similar to that of a patent practitioner working out of their technical depth. So they didn't really understand the technology they're looking at. They can write things that look plausible, but since they don't really understand it, it's maybe not substantive. It may not actually get around the rejection, or it may not actually claim anything new, or in this case, may not actually have written description support, even though it sort of looks plausibly like it might. Yeah. Yep.
Or for now.
For now, exactly. For now,
right?
I mean,
when Chat, I was just gonna say, when ChatGPT went from version 3.5 to 4, it went from like barely passing the bar to scoring in the 90th percentile. So like half tick version. And that's where I think like the big asterisk needs to live on a lot of this stuff, is that, buyer hugely beware right now, because this is like bleeding edge frontier. These capabilities are there, but they're like highly untrustworthy. ... But don't get lulled into complacency and thinking it's going to be that way forever. These things are game changing, and they're going to improve at exponential rates that we're probably not even fully anticipating or ready for.
I totally agree, absolutely, and like this is it. Well, we're about to get into the generative stuff, and then the transition into the discussion about implementation. But in terms of implementation, any of these tools, there's a learning curve. There's some investment in time that a patent practitioner has to put into learning a new tool, yes, but also testing it. These are highly important and high stakes documents. You can't just trust a new tool. You have to, spend a lot of time in the beginning making sure what it outputs is what you think it does, etc. And there's a very valid question, I feel, about when is the right time to put in that investment, and is it really now? And this is now really getting into it all, is that depending on what types of applications you typically write as a patent practitioner, that could change which tools are the most valuable for you or save you the most time, et cetera. Right? So, exactly. Thanks
absolutely.
for bringing that up, Josh. Yeah, exactly. Yeah.
I just want to mention.
Go ahead. Go ahead.
I just kind of had two examples on this just real quick. One, it was like finding a difference that was very, very like textual based, and it was great for that. But then in another example, in 2 minutes at looking at the figures, you could see what the difference was like that. And then almost trying to like handhold it to get to what you're already assuming, it was painful. It's just kind of funny how it is very based on what you're comparing.
Yeah, and I would say the best use of something like this that is sandboxed, that you are not opening up to generation, is feeding it patent applications or documents and asking it for a summary, because those summaries can be used when you discuss things with examiners, when you discuss things with clients, or let clients know what the art is about, without a whole lot of you digging into that full document, right? Because sometimes you want to give an office action, say we will come up with a plan, but here's what's cited, here's what's rejected, and here's what that art's about, right? So a nice topical thing before you really dig in.
Yeah. An efficiency tool, improving the product, improving our work product, our communication. Allowing us to do more with less time and money, right? So to finish up this section, there's two sort of slides now on drafting. And the first one, so they're split up between rule-based and machine learning systems like ChatGPT, like these large language models. And there's a nice, I think a nice heuristic to remember this, or what's the difference, is that machine learning systems are probabilistic, whereas rule-based AI models are deterministic. So rule-based models are very predictable. You know what they're going to output. They're not going to hallucinate. ChatGPT, large language models, are probabilistic. They're working on, well, the next word in this sentence was probably this. And so therefore you end up getting strange results sometimes. So just to summarize sort of rule-based drafting, you can take a patent specification, let's say it's got 10 figures in it and everything's numbered in the spec, and you want to insert a new figure between figure 3 and 4. Well, instead of renumbering all the figures by hand, if the patent is drafted in a way the AI can understand it, then you can automatically change figure number 4 to figure number 5. And there's even ones that will take, well, maybe figure number 4 had reference numbers 410, 420, 430. It'll take all those reference numbers and change them to 510, 520, 530. There are tools that do that in the specification and also on the figures themselves. This is all rule-based. It's not making things up. It's taking a claim in some cases or a description and outputting a flow chart, let's say, that has all of the elements of a method claim, or outputting, you can have it make up element numbers and overlay that on a figure that you give it in the case of a system drawing. Or there's tools that automatically generate system drawings that are box drawings that can be nested and connected with lines and things like that. And these things can all work vice versa. You can start with claims and generate detailed description. You can start with detailed description, generate claims. There's all kinds of different tools out there. And, even more simple things, but that are time consuming, where you could take a set of claims and have it generate a blank claim chart to start that you could fill in as a start of an FTO. And so it might save you a few minutes of formatting. But if you're doing that for a lot of patents or you're doing that regularly, that's annoying. And a few minutes of formatting can be, and add up and be really a time saver. Rule-based systems are great because there's a low error rate. Sometimes you need to change your drafting style so that it understands it. In some of the tools I've worked with, for instance, if you say figs 2 and 3, it gets confused. You need to say fig 2 and fig 3. Or else it won't be able to deal with that. Small things like that. But there's also a lot of limitations compared to these machine learning or large LLM, large language model based tools. So when might you use a rule-based tool? When there's a high danger of error and when you need really speedy outputs, things like that. When do you need to go to a machine learning tool like ChatGPT? Well, when simple guidelines just don't apply. You want it to summarize, as Kristen just mentioned that example, you want it to summarize a document. You can't really do that with rules. It needs context. It needs to have a lot more involved in that. And also another interesting thought is pace of change. It could be done by rules, but those rules are constantly changing. It could be more efficient just to implement something that's more machine learning because it's more adaptable. It adapts on its own. In terms of the LLM-based stuff, there are all flavors out there. You can take a patent and it can auto-generate a title or an abstract. It can generate backgrounds from prior art references that you feed in, detailed description from claims and vice versa, but not in a rule-based sense, but in a probabilistic sense, in a creative, generative sense, which is more error prone. You need to do a lot more checking to make sure it didn't hallucinate, but it can also come up with really nice language and ways to phrase things that you don't have to develop yourself. So that can be a time saver. This comes back to, probably currently, I think the most effective way that these large language models are used is with a patent practitioner and an expert who is trained in the subject area, trained in patents, and also is a good prompt engineer who knows how to ask it, not just say, here's an invention, generate a whole detailed description, but right now I need a description of this aspect of the technology, or where it's sort of almost writing paragraph by paragraph or section by section. I need a paragraph that describes the advantages of my technology compared to this prior art, and they can give you a good starting point, and then you're getting the sections and the content that the patent actually needs. But there are also tools where you take one sentence and it generates an entire patent, claims, background, so everything from one sentence. So yeah, they're all different flavors. And some of these other things here we've talked about already that, LLM generated drafts currently can look like someone working outside their technical field who is out of their depths. And AI generated drafts, responses, and third-party observations can appear responsive, but fail to make any substantive points or claim anything of substance. And this is the challenge. This is why patent practitioners definitely now, but maybe even for going forward, will always need to be part of the process, because this is just how large language models work. They work by leveraging known, often published, highly published things. And patents, by definition, are novel and new, and are not, all the aspects in them are not going to have been described sufficiently elsewhere. So from that aspect, you can imagine that there always needs to be some patent practitioner in the loop But as Josh said, these things are getting better all the time, and it's, yeah, who knows what'll happen 5-10 years from now? Who knows where the technology will be? And so yeah, I don't know. Any thoughts on that, right?
Only one thing I wanted to add that I thought was interesting. You're talking earlier about sort of the high stakesness of the document, right, and how long it's going to live. Ashley's talked to a lot of inventors about this. We kind of did a informal thing at a conference we went to, like, hey, if you could use a tool to draft a patent for you, inventor, is that something you would be interested in doing? And sort of like cutting the agent or attorney out of the loop. And the vast majority, overwhelming percentage of people we talked to said that for the reasons you stated, the importance of the document, the expense, how long lasting it has to be, et cetera, they didn't feel comfortable even doing sort of like a computer assisted walkthrough sort of thing. Like they feel like they would always want a professional in the loop. And that's straight from the mouths of inventors, cost conscious, folks and stuff. And so, for anybody out there who's listening and worried about their job going away in totality, it's probably not going to happen anytime soon. Maybe not ever. The world's going to definitely look different, but hopefully there will always be a place for us.
Yeah, I think we will. I think even if this AI movement takes 10% of our job away, it will be the 10% that we did not want to work on to slog day in and day out anyway. So I think it'll be okay. And one thing I wanted to say about the prompting that David was talking about, if you all remember way back when the search engine was fairly new, and then we had kind of a second wave of search engines that were even more robust, people had to learn how to use those from a searching standpoint, right? There's knowledge graphs and algorithms behind the scenes working that the average consumer has no concept about. And so throwing a search at that to get the right answer that you're actually looking for was really difficult in the beginning. And your Googles and your Apples and your Microsofts took a lot of effort and a lot of time trying to figure out context and trying to utilize keywords put into their browsers in a certain way so that they could provide those results accurately and better than their competitor, right? So I think with AI prompts, I think this will move along very similarly, and we'll get inventors and drafters and just the general public who gets better at creating prompts that work better for them. But there's a good chunk of the population that, and I would say well over 50%, if I'm guessing, that just gives up after it doesn't work right the first time and just doesn't have the patience to stick with it and create these better ways of using a tool. So I wonder if AI will fix that problem with society and begin to generate the prompt themselves and give choices and let them as a user decide what they were really looking for when they said XYZ. So we'll see. It might be better than prior search engine usage,
but also, I mean, and it's a little bit, I mean, I guess it's a little bit out of scope for this conversation, but I think it's highly relevant. The points that David made earlier about sort of different inputs, different outputs, and there being an art to prompt engineering. I think that's one of the biggest pieces that's sort of missed in the conversation around inventorship and authorship when AI is involved, right? Is that AI is a tool. Like my compiler is a tool, like my digital camera is a tool, like Photoshop is a tool. We're all going to use those things, and we're going to get very different results based on our backgrounds, what we put into it, and how it's sort of massaged and tailored along the way. And so just want to throw that out there that there seems to be like a lot of pushback around the use of AI with regard to inventorship and authorship, but I think that's a mistake. I think that's sort of over analyzing AI's role relative to every other tool that came before it that we wielded to create things.
Yeah, Josh, agree absolutely, and Kristen too. That the prompt engineering is really important, and It's a but for question, and it's simply it's a but for, but for that prompt you put in, that invention wouldn't exist, right? So the person is
Right.
there. And then one last, just to sort of build on that and hand it over to Ashley. In addition to all of the user training and prompt engineering, I think that what we will probably start to see are more specialized tools in certain technical areas. So mechanical, if you're dealing with a lot of mechanical inventions, compared to software inventions with a lot of methods, or compared with biotech with lots of DNA sequences, like those might all be very different tools that I think you might see AI companies for coming out with particular tools for particular technology areas or workflows that are really could be beneficial, that have specialized, yes, the prompts are still important, but they have specialized tools behind the scene to help put those, do what those individual applications need. So with that, I will hand it over.
Great primer, and I think it's actually going to reinforce it's kind of reinforce a lot of things I'm going to say here and kind of reiterate them. So I do think that and kind of you've already mentioned these, Dave, the three main areas of innovation, for how it's going to impact the patent system are probably around quality, really the PTAB, the Patent Trial and Appeal Board, and that kind of goes towards the quality. We were talking about the gold-plated patent, maybe having better prosecution, reducing the role of the PTAB, maybe longer term. But also, I think there's another, and I'll show a graph about this, there's a shrinking pool of early career practitioners. There's fewer people coming into the patent space. And so are we going to be able to, fix that with AI as well? So, for PTAB, everybody knows, that it's a huge problem. I think many of you may have heard of the Priest-Klein hypothesis, right? That in any adversarial institution, the decision rate should be right around 50%. And this is due to the selection effect, right? Where each side is exposed to more and more information at each point, and it gives each side more opportunities to either back out or to settle. And so most lawsuits don't make it to trial, and most disputes don't make it to lawsuits. So by the time you get to the final court decision, these are all the borderline cases that are being decided. And so that's where you're going to end up with that 50-50 mark. And so I think when you look at the PTAB rates of 84%, it's clearly an institution that's out of balance. And it's actually, this rate is not seen in any court system in the United States. Actually, the U.S. court system has roughly a 40% invalidation rate, and that's not unusual, but this rate is, kind of bar none in terms of institutions, at least in the U.S. So that's clearly, I think, something that AI might be able to address, and I'll kind of talk through why, and we can speculate how. And like I said, the early career practitioners, too, there's a big drop-off happening in people coming into the patent space. And so that's usually a lot of the younger workers that do more of the work that's guided by older professionals. And so if you start having fewer younger people coming into the space, that's going to drive the cost up for people to play in the patent system, right? To have a practitioner work on their stuff, it's going to be a more senior person that's going to potentially be more expensive. And so that's going to create some issues in the patent system as well. So the goal with AI, of course, is to kind of bridge this gap to make sure the patent system is as good as it can be moving forward. And so I think, like I said, quality searching is one of those areas that Dave talked a ton about, and I think prosecution is the biggest piece. But I think litigation and post-grant proceedings, what if we had better prosecution, more art found, all these things earlier, then the PTAB situation without any political, Congress input might actually kind of rectify itself, right, and get back to that 40-50% where it should be, because maybe more art was surfaced earlier in the life cycle of the patent. So it's an interesting, obviously it'd be great if Congress could enact some, backstops on the PTAB, like standing and things like that, but void of that happening, having examiners leverage more AI. And I actually didn't know that examiners were already doing that, Dave. So that was really interesting to know that you're already seeing some. Do you know if it's like USPTO sponsored tools, or are these tools, how are they getting access to these tools? Do you know what they're?
It's a good question. I'm not exactly sure. I'm sure it's with usually anyway, these are with partnerships. So I think it probably is a partnership. And as we know, sometimes even those searches are outsourced to third parties. So, because good question, I'm not sure.
Yeah. So I think, there's, I don't know if anybody has any other comments about quality and searching, but I think that is a huge area where it will improve the patent system and kind of make some of these institutions more normalized for how they should behave. And then I love the idea. Oh, go ahead.
I'm hopeful, but I'm also skeptical. I think we've all seen sort of good searches from examiners and less lower quality searches from other examiners, and maybe that by taking the person out of the loop and having of not relying so heavily on the individual examiner pulling out keywords from a claim manually, but rather plugging an entire claim into a search, maybe that can improve the quality. But as we've all talked about, prompt engineering and the human in the loop is still so important with where these tools are at now, that I'm skeptical, but I'm hopeful that they'll improve and that it will be able to make at least some impact.
Right. Or maybe there'll be like prompt engineering for examiners, right? Like do your normal Boolean searching, which you're already probably trained in, and then we're going to do some prompt engineering about how to more effectively use these tools to find more art, right? And so interesting to see.
Or you take prompt engineering out of the loop, and the input is a drafted patent document, right? And then it's like a little bit less user dependent, and it's more algorithmic to just basically say like, try to invalidate me.
That'd be really impressive. If you could find that. Yeah, that's probably the holy grail, right? Like going through examination, what's the, but I mean, it's ultimately down to the claims, right? The claims are the things that are being invalidated, right? So you'd still focus on the claims.
Right. Yeah.
And then, love the PHOSITA, point, there is already, a lot of companies, again, how do you make, court cases and stuff and reduce hindsight bias, which is a huge problem with the PTAB, is that, it's easy to say that something was easy or something was well known when you're 20 years removed from it or 15 years removed from it. So I think, how do you use AI to kind of define what was known at any one point in time in history? And there's lots of, companies already out there that are using AI for you to be able to have conversations with dead relatives or historical figures. And so obviously that person is fixed in time, right? And so, could you do that to say, well, I want to know what somebody knew in the semiconductor space between 2000 and 2001, and give me, kind of summarize, all of the publication material that was known at that time, in 5 pages. And could that almost be like not like an expert witness, but an expert testimony or something that goes into the record about what was kind of known. You could still have your, people, witnesses and things like that and experts, but, does this provide some kind of backstop for hindsight bias? I don't know if anybody has any thoughts. I
don't know. I don't know the answer to this question, but I wonder if data storage could be sort of an issue. I know that a lot of the models are constantly being improved, and I'm not sure how much data or how easy it is to roll them back. And if you need to save that every day, I have a feeling it's a solvable problem, but it may take a dedicated player who really wants to do that and has a value proposition to do it.
One could mark the data for year, right? Like, is the data actually being marked in a chronological way, right? Like, here's the data. Yeah.
And, you don't have to store the entire data set copy over and over and over again. You just have to store the deltas between. Like, we've already solved this problem with, with source code repositories and version histories and Google Documents, and stuff like that. And to take those like same concepts and apply it to like this like time traveling PHOSITA that has access to the entire corpus of human knowledge that's time stamped, right, and can erase the hindsight bias and the unringing the bell. There's just, I know that those are obviously really, really hard problems, but I think it's also incredibly exciting in terms of what could be done. We're not going to, we sort of going to have to rely on the politicians to solve the eligibility thing. Like, I don't think there's anything AI can do with that. But when it comes to obviousness and prior art and even enablement, I think we can get theoretically a long way there in terms of more patents that get granted from the office being something closer to a property right, like the title on your home or your vehicle or something else that you can more safely, reliably, predictably build upon without having to worry about the rug getting pulled out from you later on because of hindsight bias or because somebody was able to find some obscure piece of prior art that was overlooked by a tired human whose kids were crying in the background and needed to get on with to the PTO meeting or something. Like there's a lot. I mean, it's very optimistic, but I think there's huge promise there.
So for this aspect, you do not need to equate AI to a PHOSITA or to any person at all. So for this exact aspect, for searching and for kind of unlocking a fixed point in time, you can do this on a factual basis with a list of facts. And this just happens to be a really good computing way to do it, right? Like a powerful computer that can make these assessments. So as long as those assessments can be proven, these are just facts in the case, right? Like Microsoft invented the browser at XYZ in time, or I think it was like Netscape Navigator, but those are just facts and we can look those up and we can verify those. So we do not have to personify this at all for this particular use case, right? For searching, for creating a point in time to say you've used hindsight bias because the first time this was brought up is here, the second time was here, and you used it against me in a way that's not correct, right? So there's just a list of facts. So we actually do not have to, anthropomorphize AI in this case.
Yeah, that's interesting. Yeah, I mean, I think I was meaning it more from just, because that's like the parlance we use. And it's more like, before someone even says, you're using this against me, it wasn't brought up then, is there a way to, in a court proceeding, say somehow, like in this 6-month time period, this was the general state of things. Like, could it, go back and say between January 1st of 2020 and July 1st of, 2020, what was, give me a summary of all the stuff that was in that space, right? Like,
and then that can be proven, cross-checked, fact-checked, and submitted as evidence as an affidavit or as a declaration if you want an expert witness to look at that and assess, right? So that can all be submitted in a case now, but this is just a super powerful, easy, and quick way to get that info, right, without having to really do the research.
And then, obviously, to Dave's point too, obviously we could increase practitioner output, right? So on a per practitioner basis, we could be more effective. And so maybe the fact that there's not a lot of younger people being interested in patent law, maybe that doesn't really matter because we can be more effective. But also to Dave's point, ton of investment required, like just assessing all the tools, figuring out if it's the right fit, maybe changing how you draft to accommodate those tools because they are opinionated about how you use the tools. Obviously, it has implications for workflow. Like to Dave's point, are you drafting mechanical or software or biotech innovations? I think that's going to be hard. I think there's going to be age-related implications. I think younger practitioners are going to want to pick these tools up easier and they are less set in their drafting ways, whereas maybe older practitioners or ones that are more seasoned in the field are, they're more set in how they draft, and it's going to be harder to adapt to an opinionated AI tool. I also know that, obviously, like things change depending on what client you're doing, what project you're doing. So I think that's hard. And then the implications have a really long tail. A lot of people in in the legal field in general don't change something until they absolutely have to because they don't know what the implications are of changing it until it's too late, right? So a lot of people don't adopt things until they absolutely have to. And so I think that will be a really interesting thing for the legal industry because I could see outside of super known quantities like the rule-based stuff where you're just helping me renumber things and you're helping me auto-generate things that I already wrote. I could see there being some pushback in the legal industry just because we don't know how future courts or something are going to view these documents. And so I think, anyways, that's kind of my spiel on this slide. If anybody wants to weigh in or has some thoughts on it.
Okay, don't laugh. I've just adopted one space after a period like a few years ago. So I was a double space after a
Yeah.
a
It does save time. That no double space.
But honestly, even if there are some age-related things and some practitioners who are like, oh, I'm absolutely not going to use it, I absolutely don't want to, I think there's value in seeing what these tools can do and how you can adapt it into your practice. Even if you don't like what it output, I guarantee it gave you an idea or a concept you would not have come up with yourself, and certainly not within that amount of time. So hopefully this tool kind of shines on its own. This set of AI tools shine on their own and people can see the value, but we'll see.
Yeah. Very true. Yeah, so otherwise I think it could be an innovation renaissance potentially, right? If people have AI capability at their fingertips, more and more people do and know how to leverage it or can learn how to leverage it, you could end up with kind of an innovation renaissance, right? With people kind of thinking more outside the box, using AI and, creating new ways of doing things. And then if AI, practitioners are more supercharged with AI, maybe, I don't know, it makes us more efficient, more cost effective. So, gives more companies cash back in their pocket so that they can continue to innovate. So, I mean, I think it could be an innovation renaissance. There's obviously like a potential other part of the world where it's not, that I didn't really get into today. But in the more hopeful sense, I think this could be really good. I think it could help us humans think differently about different areas of innovation and maybe do better and more. But we'll see. And like I said,
Yeah.
the future has not been written. There's no fate. Go ahead.
No, I absolutely agree with that. That most of what we've been talking about are text generators and the machine learning, that side of machine learning. And I think you could even group AI image generation in there as well. But there's like a whole other side of AI and machine learning, which is like image recognition and voice recognition and big data. And I mean, I know there's like really interesting companies out there now who are doing virtual experimentation, where you can you can do for engineers and scientists in a physical science setting, where you can feed it a whole bunch of data from previous experiments, and then it can do its big data thing and predict how future experiments are going to work, which can save huge amounts of time in the lab, make things a lot more efficient. And so it's already happened in some industries and to some degree, and it's only, I think, going to be happening more. So I absolutely agree with this renaissance, or this like that AI is really going to enable a lot of things to the speed and the pace of a lot of things to improve. Yeah.
Absolutely. Does anybody else have anything else to add? So I think that was great. So thanks for setting that up. Awesome, Dave. Appreciate it.
Yeah, thanks.
I was just curious on your guys' thoughts of, like, I don't know how, we're talking about AI and legal and how it's going to shape it. One example I had seen was, I think it was a LinkedIn post, but the guy was talking about how he was using, it was ChatGPT or something, but to, surf the internet for infringing products based on claims. And he was saying that it was working so great, but it's now being choked back on the legal side. Now he tries to do the same thing, and it says, you should consult with a practitioner or legal counsel, and
oh, funny,
being choked back. So I don't know. So I think that's kind of an interesting.
My guess is that's like probably those big companies trying to CYA a little bit, since all of the copyright stuff happened. Who knows if they're not putting some of those safeguards in other areas of legal where it's like, because it's kind of libel, right? You're kind of suggesting that a product is infringing, and if it's not really true, it's kind of, yeah. Anyways, who knows if that's where some of those safeguards are coming in, of just, hey, here's some stuff, but consult somebody.
Yeah, I applaud the OpenAI and those companies for doing that. Like early, there was if you asked it to generate references, it would make a list of references that were completely fabricated. And then I think in an improvement, they said, well, we can't give you individual references, but here are some common points in references that talk about that. So they're trying to make it more accurate, less misleading, right?
So don't write your appeal brief on it.
And use your fake case law, which is happening. I think that's the inherent issue that I have with AI. It's not that it's AI and it's powerful and it can do this. I think we can put guardrails on it. I think we can manage what's going on and we can use the information appropriately. We can't manage people well, right? And what they're going to do and how they're going to use it and how they're going to be stupid or, irresponsible. And that's really tough to not be able to trust your population to like take this beautiful tool and use it appropriately, like, respectfully and appropriately, right? They can't even do it with toys, right? It's like, But
back in my IT days, we had something that was called a PEBCAC error, and what that stood for is the problem exists between the chair and the keyboard.
Yep.
That problem AI will not fix. I mean, not until it rolls us entirely.
Yeah, it'll fix us, Mike. All right. Well, we
had a good run.
Yeah, exactly. We got to go, but awesome. Thank you, Dave. I really appreciate it.
Yeah, thank you.
Thank you both.
Thanks, everybody.
Good discussion. Yeah.
It was good.
Bye.
All right. Talk to you tomorrow. Bye-bye.
Thanks. Bye.